One very important consideration in estate planning is where you own property with another person. And one of the most common situations where people own property with another person is in marriage relationships or in de facto marital relationships. Also in business dealings, in partnerships and other business relationships. Whatever the relationship, sometimes they break down. Let's take a scenario of a marriage relationship where a husband and wife own property together. Now there are two ways of owning property with another person. You can either own it as tenants in common or as joint tenants. If you own property as joint tenants and one of the co-owners passes away, then the property automatically becomes the sole property of the surviving co-owner. If you own property as tenants in common, then it's held as different and separate shares in the property. And so when one co-owner passes away, that person's share in the property can be given under their will, and the surviving co-owner retains their share in the property. If there's a marriage breakdown and property is owned together as joint tenants, then the surviving spouse becomes the sole owner of the property. Sometimes that has unintended consequences, particularly where there is a breakdown in the marriage relationship. Once that happens, it's very important that the ownership be changed immediately from a joint tenancy to a tenancy in common. And I have seen a situation where a husband and wife separated, owning property as joint tenants, and then one of them, before any property settlement or division of property was done, one of them passed away, meaning that the entire property automatically passed as a matter of law to the surviving husband or wife. Now you don't want that to happen, so it's important where property is owned as joint tenants and there's a marriage breakdown, it's important to change that co-ownership immediately from a joint tenancy to a tenancy in common. And the method of doing that is what's called severing the joint tenancy. And that can actually be done very easily, and it's important that it is done in the breakdown of a marriage relationship. Now, as I mentioned at the outset, not only spouses or de facto partners may own property together, there may be other circumstances. Extended family relationships are a common example of that, where, say, parents and children or siblings go into ownership of an investment property together. What happens sometimes is that one or more, but not all, of the co-owners want to sell the property. So what can you do when not all the co-owners agree that a property be sold? Well, again, the law has a solution. And what you can do is, if you can't get agreement between the co-owners, is you can apply to the court for the appointment of a trustee for sale, what's called a statutory trustee for sale. And that trustee then has authority to sell the property and distribute the proceeds of sale among all of the co-owners in their respective shares.